Good afternoon, everyone. Thanks so much for joining us today. My name is Stephanie Creedon, and I'll be your host for today's webinar on Hot Topics in Compliance, ESIGN. Before I introduce today's presenter, I'd like to go over some housekeeping items. Today's presentation will last about 50 minutes, and the slides can be downloaded at www.wolfandco.com/webinars/2019. You'll have two options for audio today. You can dial in by phone or listen through your computer. Our audience will be muted during this session, so if you have any questions, please send them in to me by using the questions box located on the webinar's control panel. We will be taking questions at the end of the presentation. I'd now like to give a brief background of the firm. Wolf & Company was established in 1911 and have 2 centuries of experience providing our clients with assurance, tax, business consulting, and risk management services, including IT assurance, internal audit, and regulatory compliance. We have over 260 professionals working for the firm and have offices in Boston and Springfield, Massachusetts, Albany, New York, and Livingston, New Jersey. We currently employ over 85 risk management professionals in the areas of IT assurance, internal audit, regulatory compliance, and Wolfpack integrated risk management. And we provide services to nearly 250 financial institutions in 27 different states and 2 U.S. territories. It's now my pleasure to introduce today's presenter, Brian Shea. Brian is a regulatory compliance senior manager who primarily works with financial institutions throughout New England. Thank you for presenting today, and I'll now hand the presentation over to Brian to get started.
All right, great. Thank you, Stephanie. So really the big things I'm going to be discussing as part of today's presentation is taking a look at ESIGN, which is really raising out there as an important law and regulation for us to deal with. In particular, areas I'm going to be looking at is how are institutions using ESIGN and electronic technologies with respect to matters such as disclosures, signatures, matters such as that. Really taking a look at your strategy. What should you consider as it pertains to getting a grasp on ESIGN? I'm also going to be going through some examples. We have the opportunity at Wolf to work with a wide range of financial institutions. We've seen examples of institutions that do it well. We've seen examples of institutions that don't do it so well. And I figured today is a good opportunity to kind of go over those types of things with you. From a overall outline standpoint, first I'm just going to begin with an overview of ESIGN, really what's the purpose, where does ESIGN come from. Then I'm going to jump into the different types of products and services that a financial institution typically would offer that would directly tie into ESIGN compliance. A large portion of the presentation is going to be on the ESIGN disclosure and consent process. This is probably the most critical component of ESIGN, as well as the area of ESIGN where the most issues tend to come up. Towards the end of the session, I'll be discussing some just additional topics, discussion points that are also just important to consider as it pertains to ESIGN. All right, so let's get started. So first and foremost, what is ESIGN? Where did ESIGN come from? So ESIGN has been in place for 19 years now. It was signed into law back in 2000. Its official title is the Electronic Signatures in Global and National Commerce Act. ESIGN was basically put in place to help facilitate the usage of electronic documents and electronic signatures. I think the feeling in Congress back then was that, hey, technology is really coming along, and the last thing we want to do is to really stifle that or hold things back due to all the various laws and regulations out there. For example, banking regulations. So with ESIGN, they said, all right, let's put this law in place that will really facilitate this process, that will put institutions, whether it's banking institutions like yourselves, or heck, other businesses that have nothing to do with banking, but nonetheless have certain laws or requirements out there dealing with signatures and documents. Let's try to put them all in a better position as it pertains to electronic documentation. That was really the purpose of ESIGN. Now, ESIGN is a federal law. And basically what that means is it applies to interstate commerce, so basically going from state to state, as well as global commerce. What about from a state level? So at a state level, we have what's known as the Uniform Electronic Transactions Act. This is basically a law that was approached in kind of like a uniform fashion. If you think, for example, the Uniform Commercial Code, very similar reasoning, and they really put this model law together, and then it was really up to the individual states to pass it. As you can see here on the slide, the vast majority of the states in the U.S. have passed it, 47 out of 50, with just a few exceptions that you see here. I think the only one up here in the Northeast is New York. That said, these states do have their own laws, a little bit different from UETA, but nonetheless, they do exist. So, for example, New York has the Electronic Signatures and Records Act. The gist of this is basically the state law equivalent of ESIGN, in particular where ESIGN is interstate, going from state to state or global. UETA applies interstate, meaning within a given state. So if you don't cross state lines at all, UETA is really what applies to you. That said, one aspect of UETA is that doesn't really get much into is the consumer consent process, which it really relies on ESIGN for. And again, that will certainly be a big part of this presentation a little later on. Why is ESIGN important? Why do we have to have discussions like this and really take it seriously? Well, we could face definite situations where we're getting hit with some sort of liability because we're not doing ESIGN correctly. First and foremost, you just have your pure technical violations of laws and regulations. But I'd advise you to look at things more big picture. So, for example, think of fees. If you're looking at your fee schedule for deposit accounts, if you're looking at fees that are imposed as part of the loan application process, there are very important disclosures that come along with this. And if because of ESIGN issues, you're not really getting these documents to the consumer properly, the argument could be had that you're not really allowed to assess those fees. Especially when you're looking at things like the LE or the CD under Truth in Lending. If you don't disclose those right, you could be liable, which is definitely not a position you want to be in. Continue thinking outside the box, though. Rescission rights under Reg Z. If you do not provide that closing disclosure properly, you haven't really started your rescission time period. So if you think of like ESIGN, electronic distribution, if you didn't distribute it properly, essentially what that could mean is that the rescission period never happened. The consumer could be in a spot where they could basically rescind that loan even a couple of years down the line, or at the very least, you might be in a spot where you have to try to impose that rescission period, really get that over with, those 3 days, and just move on. Also, just think of it from an EFT standpoint. Under Regulation E, Electronic Fund Transfers Act, there's actually time periods that come into place over card errors or ACH errors or things like that, and they're really all tied into when that statement goes to the customer. So what if you're in a spot where you did not properly provide an electronic statement? Basically, you're in a spot where for the consumer, that time period or that window to report errors could be greatly extended. And from your side, from the institution side, you might just be stuck in a situation like that where you can't really get the money back from the merchant because it's been so much time, but you still have an obligation back to the customer to give them their money back. So I guess really that the key point I want to get across here with this slide is that, when it comes to ESIGN compliance and getting things wrong, we go a lot further beyond just technical violations of laws or reg itself. Definitely, you could be held liable for much larger things. All right, now I'm going to briefly walk into the types of products and services that a financial institution offers where ESIGN is typically going to come into play. From a deposit standpoint, we've really seen the usage of electronic accounts or electronic services explode over the last 10 years or so. I think probably the majority at this point of the clients that I work with offer at least some of the services on this slide. Whether it's online account opening, heck, I think there's some institutions out there that just solely offer deposit accounts through the online channel and don't have a brick and mortar branch presence at all. Electronic statements, that's probably the most common and popular service I see out there from an electronic standpoint. If anything, I struggle to think of clients I have that don't offer that service. When you think of some of your traditional, EFT access device services, such as online banking, mobile banking, bill pay, person-to-person transfers, all those types of things, we typically always see those online because just the very nature of those services are to be online in some fashion. But also think of some other periodic notices, changes in terms. A lot of times I get questions from my clients about, hey, I've realized I have to send out this mailing for whatever reason, whether it's a fee change or an adjustment to a product or service. And a lot of times institutions are trying to knock down the postage cost, the mailing fees, all those sorts of things. So, that's certainly one possible avenue if you're doing e-sign correctly, where you might be able to at least knock down how many customers you have to mail stuff out to. Even sometimes on the Reg E side with foreign remittances, we still at times see some institutions that utilize electronic means to provide those documents. On the loan side, we're certainly seeing a big usage of electronic documentation as well. Probably the most common thing I see on the loan side is online mortgage applications. Certainly, entities like MortgageBot are very popular these days. At the same time, we often see other types of products as well, such as equity products, and at least having the ability for the consumer to apply for those online. We are seeing situations where institutions are providing disclosures as part of the loan process through electronic means. One thing we've seen at many institutions is some sort of web portal. Those of you that work directly with me in the compliance department here at Wolf probably are familiar with our secure portal process, whereby we transmit secure documents. Many institutions have something very similar with their loan applicants, where they establish this portal and use that to kind of get across some of those documents, such as the 3-day disclosures like the LE or various other documents as well. Appraisal distribution, we've seen requirements come out on that under ACOA the last few years about providing appraisal copies. So certainly see some institutions providing that electronically. Certainly some loan products have statements just like deposits, whether it's home equity lines of credit, credit cards, other open-end products, sometimes mortgages depending on your size, and changes in terms as well. I don't think changes in terms are as common on the lending side, but we certainly do see some instances where institutions do that electronically as well if they have the opportunity to. One important thing to consider when it comes to e-sign is that there are certain disclosures out there that do not require us to go through the e-sign consent process. If you're starting up a new online product or service, I definitely start by taking a look at if there's any documents or disclosures that don't require that consent to happen, which would certainly make that process a bit easier for you. So that's really what I'm covering over the next couple of slides here. And for the most part, I would say these are common sense stuff. The very first one, under ACOA, there are certain application related disclosures that really go right with the application itself. So, for example, I'm thinking of government monitoring information, the race, the ethnicity, the sex information, and usually there's some language that goes on the application about that, kind of explaining that to the consumer. I think there's certain language, for example, about collecting income, where you talk about the fact that, if this is from child support or separate maintenance payments, you don't have to actually provide that information. It's really stuff like that, stuff that really goes with the application itself. So under ACOA, it says that you do not have to get e-sign consent to provide those particular disclosures. Certainly when it comes to certain variable rate lending disclosures or products, such as adjustable rate mortgages or home equity lines of credit, there are certain application disclosures that go right with that application. The charm booklet, I think there's a HELOC booklet, there's program disclosures, those types of things. So luckily for those types of documents, we don't have to get e-sign consent for those. Likewise, on the credit card side, most of my institutions don't offer credit cards, but if you do, I think there's certain application relating disclosures as well that kind of go with that. Advertising, certainly there's advertising rules we have to follow. When we have triggering terms on advertisements, we're typically in a spot where we have to provide certain disclosures. I think this is one of those common sense ones. It's just really impractical to go to the consumer and try to get consent to comply with advertising rules. HOEPA disclosures, vast majority of my clients don't deal with high-cost loans that require these, but I believe there are certain ones under HOEPA rules that you can provide electronically without consent. And then lastly, if you look at Truth in Savings Act on the deposit side, there are certain situations where if the consumer comes to you and asks for a product disclosure, you have to provide it. And in that situation, they're saying you don't need e-sign consent. So again, this is just a good list to take a look at. Certainly it doesn't cover everything that goes along with the application or account opening process, but there certainly are certain documents in that process where you don't have to get that consent first. And that's definitely something you can consider when you look at how am I structuring the flow of the application process or the opening process. When am I providing certain documents, disclosures? You can certainly keep in mind that some of these things don't require that e-sign consent first. All right. One other important thing I really wanted to discuss before jumping into the consent process. I think a lot of people view e-sign as like a optional law in that, hey, I could be an institution that doesn't necessarily want to provide electronic disclosures. And if that's the feeling I have, if that's the opinion or the approach I want to take, I don't really have to worry about e-sign. And I guess I'd caution you to a certain extent in that there are certain circumstances as laid forth under the regulations, where if you're really starting an account opening process or a loan application process electronically, there's an expectation that you're providing certain disclosures as part of that process. So, for example, I believe ACOA in the commentary includes some discussion of this. One important thing I think to keep in mind, and I think this is probably a good example, is a person comes in to apply for a loan. Under what circumstances, if I want to provide certain disclosures, do I really have to get that consent? And I think the example that's provided is, is it the borrower or the applicant's device that's being used? Is it the institution's device that's being used? I think I have some clients where they may not necessarily have a paper loan application, but rather the MLO will sit down with the applicant and actually fill in information on their laptop for that application. And I think the reasoning or the stance, I guess, the regulators are taking in a situation like that is that, that's not the consumer's computer. They can't really necessarily access the disclosures through that computer. So don't think that by providing documents through that computer, you're covering yourselves for e-sign. On the other end, if the consumer is using their own device, if it's a tablet, if it's a laptop, something like that, and that's how they're submitting their application, then usually the reasoning is, hey, if there's certain application-related disclosures, you should really be providing those at that time. Again, I think of something like an ARM product or a HELOC product where there's really critical disclosures that have to go directly at the time of application. I guess another important thing to keep in mind here is state law. There certainly are certain lending disclosures under state law that have to be provided at the time of application. Unfortunately, many of these laws are so old that they didn't consider the electronic process. Massachusetts, for example, I know there's a attorney-related disclosure, the MGL 184-17B disclosure that really has to go at the time of application. And I don't think there's really any explanation or exemption if it's a situation where the consumer is not in person. So if there's a circumstance where you're getting an online mortgage application, you really want to be providing that state disclosure at that time as well. And that's a situation where, unfortunately, you have to go and get that e-sign consent too. From a deposit side of things, basically the gist is that you have to make sure you're providing the disclosures before the account is opened. I think Truth in Savings Act, Reg DD in particular, talks about this. So it's really critical as to what is happening when a consumer is putting stuff in online. Are they really just applying for a deposit account, or are they actually fully opening that deposit account online? Because if they are opening that account online, you have to make sure you're providing those disclosures as part of that process. You can't just say, hey, I'm going to mail these out 10 days later. But if you are really just accepting like an application, they fill in certain information about themselves, but they really don't go the full way to open the account, then the regulators have said that's a situation where you can mail things out afterwards. This also just, I think, comes into play from an EFT standpoint as well. One thing you have to consider is that when a consumer is getting a new access device under EFT, such as a card, online banking, something like that, typically in those circumstances, the consumer has to get a disclosure either at the time they contract for that service or prior to the first transfer. So you just have to make sure that you're getting that disclosure over to the consumer before they start doing activity on that device. And sometimes really the only option to do that is to give that when they're actually online getting it. All right, so that's really some coverage over what types of products and services I'm seeing out there being offered electronically, and what are just some of the things to consider as part of that process. The next thing I'm going to focus on is the ESIGN disclosure and consent process itself. I feel it's important to do a deep dive here because this is the area where we do tend to see the most violations and issues come up. The way I'd like to approach this is, and I mean, obviously this is my opinion, you don't have to do it this way, but I think this is a great way to look at it, is to think of it as a timeline. You really have to do certain steps or follow certain processes in a specific order to ensure that you're in compliance with ESIGN. The good news is it's not that complicated a process. Really what I have here is just 3 key steps that you do want to follow. The first step that you have to follow is that you have to make sure that you provide the consumer with a statement of their rights under ESIGN. We typically just call this the ESIGN disclosure, and I will be getting into the content of that in a slide or two. After that, you have to make sure that the consumer consents for electronic documents or records in a fashion that evidences to you that they can actually access things electronically. That's a really important piece, and I will be diving into that in a little bit as well. Once you've done those 2 steps, so you've provided the ESIGN disclosure with the consumer's rights, the consumer has electronically consented, now you're basically at that point where you can start providing those electronic disclosures. Obviously, to the extent that the ESIGN disclosure describes those circumstances. In that situation, you can basically now continue to provide those electronic disclosures until either the consumer withdraws consent or you have some sort of hardware or software change that impacts how the consumer is able to access those documents. I want to dive a little deeper now into the ESIGN disclosure itself. So this is a disclosure of certain rights that the consumer has and has to basically receive as part of the ESIGN disclosure process. This slide and the next slide have a total list of basically 7 key things that need to be in that disclosure. I'm not going to spend a ton of time going through literally all 7 of these, but definitely make sure you read up on the slide for some of the specific info here. Really, the things that I did want to highlight that are probably the most important on this first slide, number 3, a description of the scope of consent. So basically, you want to make sure that it's very clear in the ESIGN disclosure what the consumer is signing up for. For example, are they solely signing up for getting online disclosures as part of the account opening process? Or is it also your intent to get their consent for even future disclosures or notices? You want a product that's entirely online. I open it online, the statements are online, the mailings are online, all those sort of things. Great, go for it. But make sure that you're fully describing that entire process in that ESIGN disclosure. If you just state, this consent applies only to the account opening documents, then you do not have consent for anything that happens after that. Another really important thing I want to highlight here was just the hardware and the software requirements. Basically, you have to describe what hardware and software the consumer needs to actually be able to get those electronic documents you're providing. The biggest piece of advice I have here, be specific. State exactly what you think they need. I think a lot of institutions use Adobe or PDF, which is fine, great. Obviously, make sure you're describing whatever browsers or browser version types that they need, all those sorts of things as well. Can't hurt to be as specific as possible here. All right, consumer has gotten that ESIGN disclosure with all these pieces of information. Now the consumer has to consent to us that they want to receive these electronic disclosures. This piece is probably the most important piece of the whole process, or at least I think the piece where we tend to see the most issues, because the important step here is that the consumer has to basically electronically demonstrate to the institution that they can access the documents in that applicable format. So, for example, if you're providing the disclosures in web page format, the consumer has to evidence to you that they can access web page format. Likewise for PDF, for Word, or really whatever format that you are providing those future electronic disclosures in. If you don't do that properly, if the consumer hasn't really evidenced that, then the argument is basically you have not properly gotten e-signed consent, and then we get into that whole liability thing I talked about earlier, because if you haven't gotten e-signed consent, then they might say, all right, you didn't provide any of the disclosures the consumer needed, you're violating all these laws and regulations, you can't collect all these fees, you get yourself in really big trouble. All right, I wanted to discuss some of the key strategies or good ways to approach things, both from the consent process and then a few minutes from a disclosure process too. What are some good things that an institution can do? What are some best practices that I've seen used in the industry? The first thing I would say is have some controls in place as part of that enrollment process. To basically put it in a spot where the consumer cannot bypass things. You don't want the consumer to be able to get to that e-sign disclosure and then consent without even opening it. I've definitely seen institutions that work with their vendor in the system to set it up that the system can recognize if the consumer is trying to skip through without even opening it in the first place. And if that's the case, they basically get stopped. So that's definitely something good to look at. One thing I have seen some institutions use, and this is probably, again, based on the technology you're using, the vendor you're using. A really big thing is, can the vendor demonstrate that the consumer consented electronically, that the consumer can access those electronic documents in that applicable format? We have sometimes seen institutions get in trouble because they can't really go after the fact back and evidence that. Maybe they can evidence that the consumer checked off a box, but they don't necessarily know for sure that the consumer was actually able to access those electronic formats. So one thing we have seen institutions try out is kind of like a passcode system. PDF, for example, let's say PDF is the format we're providing the disclosure in. They actually initially provide the consumer with a PDF document that has a passcode in it. And then once the consumer opens that, they just basically type that code into the applicable web page that they are consenting through, and the fact that they have that code evidences that they were able to access and open that PDF document. That's definitely a great idea that I've seen out there. Definitely something that's good to consider. Sometimes I've actually seen institutions that have said, hey, let's do the whole process through the web page. Consumer is coming online to our website to even apply for this in the first place. All those inquiry screens they initially go through to fill out their application, that kind of thing, that's all in a web page format, HTML format. So let's just provide those disclosures through the same format. We already know that the consumer can access this format because otherwise they couldn't get to this web page to do this unless they could. So I've definitely seen that in some places. I think probably more on the loan side of things, definitely at least some places where certain lending disclosures are all provided through this uniform web page format. All right, so those are some good best practices, some good ways to do things. What are some pitfalls? What are some mistakes or bad things that we don't want to do with respect to this process? And, some of these are kind of just like the opposites of what I already discussed. So, for example, the consumer having the ability to bypass the e-sign disclosure without even opening it, or just bypass the consent process and immediately start getting those electronic disclosures. Unfortunately, sometimes your institutions run into plays. It's just a system or a vendor issue. The consumer got through everything okay as far as we can tell. No complaints. They've been using their account and everything. But then when it comes time for the audit or the exam, the vendor doesn't really have sufficient documentation to evidence that the consumer was able to access things in that format. So we have seen institutions get in trouble for that. How about getting consent through a different manner than the way that those subsequent documents will be provided? So, for example, I'm going to get consent completely through a web page format. Even my e-sign disclosure will be in that web page format, but then all the future documents I'm going to provide are going to be in PDF. Well, unfortunately, in that situation, you didn't get the consent in a format or fashion that evidences that the consumer can access a PDF document. So unfortunately, that consent isn't really valid. The FDIC had actually issued a newsletter talking about e-sign. This was back in September of 2018 that had provided some examples of issues that they were seeing coming up in exams. And actually, one of the things they did mention was very similar to this. I think it was a situation where they were providing loan disclosures via a web portal. I know I discussed that earlier as one option. And what was happening was the institution was getting consent from the consumer that they could access the web portal. Great. The problem was all the loan disclosures were going up in a completely different format. The portal was really just where the disclosures were being put, but there was no actual evidence that the consumer could actually open those electronic disclosures. And unfortunately, that institution, as far as I can tell, based on what was in the newsletter, got in trouble. What are some other things to avoid? How about getting consent in person? If you're an institution that has a consumer sign a paper form for ESIGN consent, all I can say is to stop that immediately, because that does you absolutely no good. Obviously, ESIGN process, it's an electronic process. It's about giving electronic disclosures. If a consumer is giving you something in paper, they have not evidenced to you at all that they can access things electronically. And that's really the entire point of ESIGN. Or let's say, a consumer comes into the branch, you hand them a tablet that's owned by the bank, and they basically do their ESIGN consent through that tablet. That's also no good, because that's not the device that the consumer is going to be using. We really need that evidence or that consent to happen from a device that the consumer themselves is using. All right, Brian, what do I do if my applicant or my customer is actually sending me emails and saying, hey, just email me these documents? That's okay. While from a customer service standpoint, that might sound great. Unfortunately, from an ESIGN standpoint, that's not sufficient. Getting an email on its own is not consent under ESIGN. Maybe you could provide disclosures through email format. If you're getting, consent through email format, that kind of thing. I usually don't see institutions do that. But if somehow you did it all through an email, in terms of providing the ESIGN disclosure, getting the consent through the email, and then providing the subsequent disclosures through that email, and it's right in the email body, maybe something like that would be okay. But what I tend to see more often is institutions like attaching something to the email, like a PDF, and just the consumer emailing you and saying, send me something, does not mean you've gotten that consent. One other situation deals more with changes, change management, that kind of thing. What happens if we go through a system conversion and then things change, or maybe we change the vendor that we're using for ESIGN or electronic account opening, that type of thing? In those situations, ESIGN actually requires you to go back and get consent again, which kind of makes sense because they only consented previously with the hardware and software you told them about before. So if you change that hardware and software requirement, ESIGN is basically saying that the consumer has to evidence it to the institution again to show that they can still access those documents. If you don't get that consent again, then it basically is as if the consumer came back to you and said, I am withdrawing my consent. So essentially, you have to go back to paper. I think that's another thing I saw in that FDIC newsletter as well. I think they were really focusing on, a situation where an institution underwent a core conversion change, and then they didn't think about the fact that this unfortunately had invalidated basically all the ESIGN consent that they had previously obtained. All right, I also want to spend at least a few minutes discussing some of the disclosure aspects of the process. So like we've discussed, the consumer gets the ESIGN disclosure, the consumer consents under ESIGN, and then you can start providing those disclosures that you have to provide, whether that's the truth and savings disclosure, the fee schedule, certain loan disclosures, all those types of things. It's really important to focus on the order in which you are providing these documents. If you think back to that timeline I had provided a few slides back, you really want to follow that process exactly. Provide that ESIGN disclosure, get that ESIGN consent. Once both of those have been done, then you can start providing those electronic disclosures. If you mix up that order, that's a situation where you could get yourself in trouble. So again, what are some good strategies? What are some good ways to approach things, best practices, those types of things? Again, I can't stress enough looking at this from a timeline standpoint, trying to really plot out these are the steps in the process, because under ESIGN, it's really important about where you're placing all these individual steps. putting e-sign as early in the process as possible. The earlier that you put that e-sign disclosure, the earlier that you put that consent process in the process, I think probably the more likely things are going to be good. Keeping in mind that certain disclosures kind of pop in at different parts of the process. If you just get that done right away at the front of the process, immediately, you don't have to worry about screwing things up later on, or providing certain disclosures and realizing, I actually didn't have my e-sign consent yet when I gave this. So my suggestion is to put it as upfront as you can, as early in the process as you can. Consolidation. I know consolidation is great in certain circumstances. I know many institutions that consolidate, at least on the deposit side, allow their disclosures into a single document, which is great. I mean, you have all these different deposit regs requiring all these different things. Can we put them together? Awesome. Just be careful from an e-sign standpoint. One thing you don't want to do is combine or consolidate the e-sign disclosure with all the other disclosures, because you have to remember that those account opening disclosures, whether it's the truth in savings, the fee schedule, whatever, those cannot be given electronically until you've gotten your e-sign consent. So if you're providing that e-sign disclosure at the same time as those, you've got your timeline messed up. Another best practice is just double checking things. Heck, when you're opening or starting up a new process, just have one of the employees in the institution go home and try to open a test account through the computer. Maybe try different versions. I know certain devices might be more popular than others, but you got to remember that every customer isn't necessarily going to be using the same device or have technology that's as up to date. So it's probably a good idea to test it through various methods. You have somebody that has a computer that's a few years old or has the type of mobile device that isn't as popular as some other ones. If you can use those to test to make sure that any consumer using those can really still access things through those devices, that would be something great to do. All right, I also want to discuss some pitfalls. Again, things to really avoid. I know I mentioned this earlier, but unfortunately I still see this in many institutions. Consolidating the e-sign disclosure and the other account opening documents in a single document. You absolutely do not want to do that. I think really the only situation that could ever really work is maybe you're opening accounts online and then you're providing statements later and you're getting that consent for the statements as part of that account opening process. And you put that e-sign disclosure in with everything else. Maybe in that situation you might be okay, but typically when we're seeing e-sign used as part of account opening, it's really to provide those account opening disclosures. And in that situation, that e-sign consent process has to be followed first before anything else is provided. Other things to look out for, just the order of things. I see some institutions that put the e-sign consent process and the account opening disclosures on the same screen. But what they do is they mix up the order. Maybe they put it in alphabetical order, and then some disclosures come before the e-sign disclosure in the order. That's no good. Again, you really got to get that e-sign disclosure out first, get that consent from the customer, and then you can start providing something else. Frankly, just a situation where you get like e-sign consent at the last screen. You've provided all the account opening disclosures first, and then you provide e-sign at the end. Again, that would be a situation where you've kind of messed up the timeline. You got to make sure that e-sign disclosure is obtained as soon as possible. And sometimes it's just as simple as the e-sign disclosure doesn't have everything it needs. I had a slide, again, a number of slides back that kind of broke out all the specific content that has to be in there. Just make sure that is current, that's up to date. Again, the things I stressed that are the most important are really the scope of what's being consented for, as well as the hardware software requirements. But certainly there are other things as well, so just make sure that you're covering all of those things. All right, I want to wrap up with some additional discussion points. These are things that aren't entirely relating to the e-sign consent process, where things are, being tripped up, I guess, the most, or having the most issues, that type of thing. But there's still things to consider. One thing is online banking and mobile banking. This is kind of interesting because obviously these devices, these services are really inherently electronic by their very nature. I mean, obviously somebody's not signing up for online banking to then say, all right, I'm going to do this all in paper. You would think that because these services are really electronic services that maybe eSign doesn't necessarily comply. And while I can say for many years, many years, I never saw an examiner or a regulator criticize providing, for example, an online banking disclosure electronically without getting the eSign consent. You got to remember that Reg E does not provide an exemption for those services from eSign consent. So you still really want to make sure to get eSign consent, even in these situations. And again, I recognize that it hasn't really been an exam concern historically, but examiner scrutiny has really picked up big time on eSign, especially the last year or so. So just because they haven't really brought it up as a concern or an issue before does not necessarily mean it's not going to come up. And again, as a reminder, I know I mentioned this earlier, but just be cognizant of the fact that if a consumer is contracting for this new electronic service, such as online banking or bill pay or mobile banking, that you do have Reg E disclosures that have to be provided at that time. I go back to that FDIC September 2018 newsletter I've mentioned a few times, which again is just a great resource for where they've been seeing eSign issues come up. And I think there was actually some institutions where the mobile banking service, there was a disclosure that went along with that. But what they were finding was that this disclosure was really only covering electronic statements. It had nothing in there whatsoever dealing with the mobile banking capabilities. So, for example, mobile deposits, those types of things. No discussion of those whatsoever. So, again, just keep in mind that you do have Reg E out there, and you've definitely got some concerns and stuff in there to look into. All right. Most of this, presentation has been on documents, electronic records, those types of things. Obviously, eSign does have a signature component as well. The big thing under eSign, and this is the case under the state equivalent, UETA as well, that basically electronic signatures are going to have the same validity as paper signatures, aka wet signatures. So, if I'm in a situation where I need a certain document signed, you can get that signature electronically. And if you were to, be in a situation where the examiners are in, or you're going to a court or something like that, in the vast majority of the situations, because of eSign and UETA, those are typically going to be considered acceptable. I think there might be the occasional, really rare exemption under eSign UETA where it says, hey, we still want paper documents. Don't do something electronically, but those are really rare. And trying to think of from a banking perspective, how often do those come up? Hardly ever. I have seen a few instances that really don't apply to the banking industry when it comes to that matter. One question that does come up to me sometimes is, all right, Brian, we're opening accounts online more and more. Do we actually need signatures any longer? Do I still have to collect those? I guess what I would say from that standpoint is it's really a risk-based determination. I think the first thing I would say is check your state law, check with your legal counsel. From a federal level, there typically doesn't tend to be much in terms of rules or laws requiring signatures. But at a state level, there certainly could be some stuff. Keep in mind that a lot of these documents is not just a compliance component. There's also a legal or a contractual component as well. So it's always a good idea just to check with your counsel to be safe. Some institutions say, all right, yep, I've checked with my counsel. I think in my unique circumstance, for my unique institution, I'm all right without getting that signature. If that's the case, I guess just think to yourself, am I going to be using that signature later? So, for example, a lot of institutions use signature verifications, looking at signatures on checks. Some institutions, when there's an address change and the person isn't right in person providing that request, that they rely on signature verification. Great. That control usually works very well. But if you never got a signature, there's nothing to trace things back against. So just keep those things in mind. Again, I wouldn't expressly say it's the Wild West and go ahead and never get a signature anymore. Really look into your own unique circumstances and situations as to, am I comfortable doing this based on the applicable legal statutes that come into play for the circumstances? Is that something I can consider? All right, another thing to consider is commercial transactions, business transactions. To this point, I've really been focusing on consumer transactions, consumer customers. But the question could certainly come up with, okay, Brian, I've got some business customers, and I really, for these business products, want to start moving forward from an e-sign perspective. How do I handle those? Right off the bat, I guess I would say that under e-sign, there's the consumer consent provisions, that whole consent process we spent a lot of time on. And that process really is intended for consumers. It's specifically worded in the law as consumer consent. So the question comes up with, what do I do for businesses? Do I technically have to follow that exact standard? What I would say is that because it's worded for consumers, I don't think you necessarily need to follow that exact standard for business customers. At the same time, I would really strongly recommend that for business customers, you still get some sort of permission, consent, that type of thing. Consider things from a liability standpoint. Do you really want to be in a position where the consumer, or the business entity, I should say, comes back later and claims that they didn't get certain key documents or disclosures? I mean, you don't want to be in that position. So I would strongly recommend that you still implement some sort of consent process. Does it have to be as technical as a consumer process? Not necessarily. Do you have to necessarily follow all those exact things in the e-sign disclosure and all that kind of stuff? I wouldn't necessarily say so. At the same time, where's the harm? I mean, that's kind of the way I look at it at times as well. We have this clearly defined process for consumers. We literally have been told if we follow this correctly, we'll be in compliance. So, do we follow that same way for businesses? It's definitely a good idea, or a best practice, even if I can't necessarily say you absolutely 100% have to do it that way. So just something to think about. I mean, I can't say I see only a fraction of this on the business side. The vast majority of the time, I do see this come up on the consumer side of things. Maybe occasionally on something like a appraisal copy. It's probably one of the more common things where it will impact possibly a commercial loan. We could see things like this come up. All right, I want to wrap things up with a discussion of really any other strategies or governance processes, best practices, those types of things that we just want to consider with respect to e-sign. Right off the bat, a thing I'll say is keep up to date with the industry, keep up to date with trends and enforcement. This is just so important. I can say, and I've been doing compliance for 14 and a half years at this point, that for most of those 14 and a half years, examiners did not really care that much about e-sign. I went years and years and years without seeing an e-sign finding in an exam at all. But it really has exploded the last year or two. I've certainly been to a number of networking events or seminars or things like that where different bankers have had the chance to talk. And a big topic has been e-sign. Lots of places. I think I was at one event where literally every single institution that had an FDIC exam within the last year said, yes, they asked me about e-sign. Certainly, I think a piece of that is certainly how much institutions are using electronic products and disclosures these days. I mean, the usage has certainly exploded there. Maybe it's as simple as that. The regulators recognize that the volume is going way up now, and now they're taking it much more seriously. But it really is an area where, we haven't always seen that level of enforcement. So I guess just keep that in mind, keep up to date with your industry, speak to fellow bankers. I think hopefully I've had some nice best practices here. It's always a good idea just to talk to your fellow bankers and see, are they doing something that's been blessed by the regulators, something that's worked out well for them? New products and service development. If your institution is developing new products and services and there is any electronic component to that, e-sign probably is going to impact it in some way. As with anything compliance-wise, I'd get ahead of it as soon as you can. Start doing it early in the process, have those discussions, because as we saw here, things like the time frame and the timeline for when you're giving disclosures and doing certain things is really important. And sometimes you got to start discussing those things early. Change management. I know an example I provided earlier was the core system change. Whenever you're having a change to the website, to the core system, to the online banking provider, the e-statement provider, I mean, these are all situations that might force a hardware-software change under e-sign. So hopefully your institution is in a spot where you are always considering e-sign compliance and having compliance people involved. Monitoring and testing, as with anything else, always a great idea to do these things. I think I mentioned earlier, trying things out, monitoring things or testing things for different devices and services, those types of things, always a good idea. And lastly, as with any compliance area, written policies and procedures are always a great guideline. I can't expressly say that an ESIGN policy is required, but it's always a great practice to have something there in place to discuss that. All right, I've wrapped up the presentation here with some hopefully helpful links, including a link to ESIGN Act itself, the state equivalent. The Federal Reserve, I know, had issued a number of years back a nice article on ESIGN. And again, the FDIC had issued a newsletter in September of 2018 as well. They had some nice guidelines. Unfortunately, I couldn't find an online link for that one, but that had some good examples of ESIGN violations and issues that have come up.
Thanks, Brian. So it looks like we do have some time for questions. If you have not already submitted your question, please do so by entering the questions into the question box and submitting it. So our first question that came through, you mentioned that getting a signed form is not sufficient to be considered e-signed consent. Are we allowed to use a signed form as part of the process in other ways? For example, a consumer withdrawing consent requesting a paper document or a signed form used as the first part of the multi-step process where the consumer will later consent in electronic fashion?
I would say yes, you probably could do that. So if I understand the question correctly, we're not solely relying upon that paper signed form, but rather we are considering it one piece of the process. And I think something like that may work. I think I did work with an institution once where the intent was to provide certain loan disclosures electronically. So what they did is they actually had the consumer, when they initially applied in paper form, actually sign a form that says, yes, I want to get things electronically. Now, that wasn't the consent. That was really just a trigger for the institution to know that, okay, I need to go through the e-sign consent process later. So I think what they did is they actually sent like an email link to the consumer. The consumer clicked on that link, went to a web page where they actually had the ability to do the e-sign consent process. So that's an example of something good. Something like that would work. I think withdrawal of consent was mentioned as part of that question too. So I actually don't think under e-sign you've got to go through that demonstration process for a situation where they're withdrawing consent. So I mean, you could have somebody just walk in person and say, I want everything in paper going forward. And I think something like that would be okay.
Oh, great. Our next question is, am I allowed to have an account that is intended to solely be used electronically, and hence e-sign is required to even have the account? What do I do if the consumer withdraws consent?
All right, so it sounds like we want a product that's completely electronic, which makes sense. I do see some institutions going in that direction. One thing you have to consider, obviously, is that you still have to go through the e-sign process. You still have to get that consent. So I think that's a great example of you want to get that consent right away, early as possible. And you want to make sure that I think we talked about that language about the scope of the consent, really what is the consumer signing up for. Make sure that properly explains that it's basically everything. Hey, I'm consenting for my account opening disclosure. I'm consenting for my subsequent periodic statements, my change in terms notices, my privacy disclosures, all those types of things. Great. Make sure that's explained in there. One thing I didn't get in a lot of detail in the presentation, but I think will also come into play, there is something in that e-sign disclosure that has to talk about consequences if the consumer withdraws consent. So I would imagine that a situation where the intent is that it's a completely electronic product, you don't want them doing anything in paper, you want to explain that properly in that e-sign disclosure. I think I've seen institutions that say, if you withdraw consent, we're going to close the account out in the next month. Or if you withdraw consent, we're going to charge you a $4.95 fee per month to get a paper statement. Something like those are perfectly fine. Obviously, just make sure you're disclosing things properly.
Next question is, if the e-sign disclosure is provided, but a verification code is being provided to demonstrate reasonable ability to receive disclosures, can they include the required disclosures in the same email that contains the code?
If I understand your question right, I guess that you are looking to provide certain disclosures. Let's see. All right, so I think this gets back to that issue I discussed earlier, consolidation. So if I understand the process correctly, or the question correctly, you initially provide a PDF document that has that passcode in it. The purpose of doing that is so the consumer can prove to you that they can open something in PDF. The way the timeline works under ESIGN is that you have to provide the ESIGN disclosure, you have to get that consent or demonstration from the consumer, and then you can provide the subsequent disclosures. So I think the intent of that passcode is really to evidence to the institution that the consumer can access things in that format. What that means essentially is that unfortunately I would not agree that you can consolidate those subsequent disclosures in that same document as the passcode. That passcode really acts as a key part of that consent process, that demonstration process, and you can't provide those opening documents until after that fact, after the consumer has proved to you that they could view the passcode and hence could open that document in that format.
Thanks, Brian. So we have just a few minutes left to answer some questions. The next question is, do you have a risk assessment for the ESIGN with account opening, a template, and or provide professional services to conduct a risk assessment for account opening with ESIGN?
So I guess what I would say is not necessarily a template per se. Certainly Wolf & Company does offer the Wolfpack online risk assessment module, which does provide assessments of compliance with various laws and regulations. And ESIGN is one of the laws and regulations that is encompassed within that questionnaire. I guess I would probably say that's the first place to go. We probably could assist you from a professional services standpoint if you did need assistance with an ESIGN risk assessment. Usually most of the ESIGN services we provide are more evaluation focused in nature. So you're an institution that has established the process, worked with the vendor, and now just want to make sure it's working properly and is in compliance, and we can definitely help there. But at the same time, if you do need a risk assessment, certainly feel free to reach out to me and we can have some sort of discussion as to if this is a good fit.
All right, it looks like our Q&A is up, but if you do have any questions after the conclusion of this webinar, please feel free to reach out to Brian directly. His information is listed on the screen and on the presentation. As a reminder, copies of today's presentation are available at www.wolfandco.com/webinars/2019. I will be posting a recording of this presentation to the same web address later on today. And immediately following the conclusion of this webinar, you'll have the opportunity to complete a survey. As always, we appreciate your feedback so that we can continue to improve our webinar program. Thanks so much for attending today, and we look forward to your participation in future webinars. Have a great afternoon, everyone.